triple J10 in brackets 1 up to 5. We had handed up color copies at the time. Now we've managed to make color copies. They remain the same. Exhibit triple J10-1, just proof of email correspondence, and exhibit triple J10 in brackets 2. That's the logistical server indicating tower locations and distances between Basotho Hostel and corner Jules and Sinclair Street. Exhibit triple J10 in brackets 3, the map depicting Lesedi and Flores. I must just mention that this relates to, as I mentioned, Malotri Towers. Then exhibit triple J10 in brackets 4, it's the map depicting the Basotho Hostel and tower locations and distances. Then lastly, exhibit triple J10 in brackets 5, the map depicting Basotho Hostel and Mleleki Tower. I've finished my learned friends with color copies as well. Then secondly, my lord, we have updated the list of exhibits. What's new is from page 8, number 102. At number 102, we mention, my lord, exhibit triple J in bracket 9. This is a request by the late Colonel Modise, dated 7 March 2016, for the analysis of downloaded data of the cell phone numbers of the people who were in the house during the incident. I'm told that this is an exhibit that was handed up by my colleague, Mr. Mgomezulu, for accused number, on behalf of accused number 1. Then number 103, these are the exhibits that we've just placed on record. Exhibits triple J10 in brackets 1 up to 5. Then thirdly, my lord, regarding the reanalysis of the ballistic exhibits by the defense experts, we can confirm that the order of the court has been complied with. The ballistic expert for the state, for the defense, and the investigating officer met on Monday last week, and the reanalysis commenced on Monday and went on until Thursday last week. And subject to confirmation by my learned friends, we were informed that the report will be ready by Wednesday in 2 days' time.
I don't want to hear what the report says.
No, I'm not.
Yeah, no, just in case.
Yeah, no one knows what it says
Yeah,
at this
fine.
point. Yes, so I'm just saying that it might be ready in 2 days' time. That is now
What was
Wednesday.
the order? It should be ready when? By when at least?
Well, there was no order as to when it should be ready. If I remember, the defense ballistic expert, Mr. Peterson,
No,
indicated
fine.
that.
I hear you. So, but in other words,
Yes.
when is the cross-examination, alleged
Yes.
cross-examination due to commence by
Yes.
defense?
Yes. What I'm saying, my lord, is that once it's ready, we'll then confer with my learned friends to find out as to when will they be ready to start with the cross-examination of Lieutenant Colonel Mangena. Now, my lord, this brings into sharp focus the order in which the state intended to present its evidence. We have indicated that we would have liked to call Brigadier Gininda, the investigating officer, before the cross-examination of Lieutenant Colonel Mangena, but that was based on the fact that the report was going to take some time to be finalized. But if it's going to be finalized on Wednesday, my lord, will then request that that we should rather finalize the cross-examination of Lieutenant Colonel Mangena that has been outstanding for more than a year, and that Brigadier Gininda, the investigating officer, will then testify last after the conclusion of the cross-examination. That is the plan for this week. And mindful of the fact that this is a 4-day week, Friday is a holiday, we will then see how things develop from Wednesday after receipt or after communication regarding the reanalysis of the ballistic exhibits. Then lastly, my lord, we have signaled our intention to bring an application for the recalling of Colonel Stay, and we have prepared brief heads in support of that application. We were told at the time that the application is being opposed, and we proceed from the premise that the application is still being opposed.
But every council, that's not how understood.
Well, Mr. Mgumezulu informed me this morning that he's not opposing the application. I haven't really canvassed the issue with my other colleagues. I suppose that their standpoint is still the same, but they can speak for themselves.
Yes, Mr. Mgumezulu.
Court pleases, my lord. My lord, I concur with my colleague to the effect that I do not oppose the application by the state.
Okay, thanks. Mr. Ramsepini?
As the court pleases, my lord, my stance is that I'm not opposed to the application. I'm not opposed, my lord.
You're not opposing?
Yes.
Yes. Mr. Nisi?
Please, the court, madam. The court will remember that I said I will have a thing or two to say with regard to the application.
You are opposing it?
my Lord, I said I had a thing.
Yes, that I did. But now the sequence is there's an application by your colleague, Mr. Baloyi, and he says he wants to ascertain whether it has been opposed or not, because on Friday it appeared that there were some persons who wanted to say they're opposing it and others said no. So where are you now? Are you opposing or not, sir?
I haven't had regard to the content of the application, my Lord. Whether or not I need to oppose it, that will be informed by what the content of the application is. We only have been handed with the written piece of argument by my colleagues. I think it's almost 20 minutes ago today. So I haven't gone through this piece of argument.
So you first want to go through the application?
Excuse me, Madam.
So you first want to go through the application?
Not the application per se, but the content of the heads of arguments. I need to go...
No, I don't understand you. There's an application to recall Colonel Steyn.
Yes.
That's the application Mr. Baloyi says he wants to launch. And then he says, in support of that, he's got heads, which he has prepared.
I don't have a problem with the recalling of Mr.
Oh, you don't have? Okay.
It only depends on what is it that is coming here to say. I think for me that...
What is the procedure? Mr. Mnisi, what is the procedure? You can't stand in the middle. You say you don't have a problem with the application.
No.
Is the problem which you have will arise as to what is contained in the application.
That is exactly my point. Remember, this application is twofold. Right? There is an application which is the request to recall Mr. Steyn. I don't know what is it that is coming here to say.
I don't know also.
To oppose it or not, I don't know.
Hey.
But now, having been issued out or having been handed with the copies of the written heads of argument, I have to go through them very meticulously and formulate a position whether do I need to oppose this application or what.
Okay, fine.
Mr.
Ngumala, you're of the same view also.
As the court pleases, my Lord, I'll definitely be opposing the application.
You are opposing?
I'm opposing the application.
Yes, without even having seen the application.
Yes, I'm
okay,
going to
fine.
go.
No
I've gone through the heads
okay.
and I formulated the decision that I'm opposing the application. Thank you.
Ms. Narolo?
Thank you, my Lord. I'm opposing the application, my Lord, on
Okay.
behalf of accused.
So you want me to adjourn for how long? To familiarize yourself, as you say, with the contents of the application.
As a court, please, my Lord, our suggestion is that we proceed with the application.
Now they want to peruse it first.
Well, I think it's only Advocate Nisi, and he said he wants to be apprised of the reasons which will become apparent when we take the court through the heads. And just a slight correction, we did email the heads yesterday evening to all counsel. They were not supplied to them this morning. It's only hard copies that were supplied this morning, but the electronic version were emailed last night.
Okay, let's adjourn for, 30 minutes, is it okay?
My Lord, on my side, the state can proceed in bringing the application, and then I'll be given an opportunity to respond, my Lord, and to prepare my response thereto to the application.
Mr. Ngumalo,
I'll just
we adjourn for
request-
30 minutes.
My Lord, I've just gone through the heads. I need to promptly prepare and reply to the heads of arguments.
You have to?
I'll be given an opportunity to prepare my heads of arguments so that I can respond promptly to the heads of arguments
So how long
supplied
do you
by the
need?
state. Overnight.
No. On Friday, all of us were apprised of the fact that not on Friday, is that whatever, Tuesday, is it? That Mr. Baloyi wants to launch an application for the recall of Colonel Steyn. We all knew that. Obviously, we were all expected to prepare. Look, I've done the preparation. Here it is. No. I've done it. Because I expected him to launch that. I can't come here. I want to hear first what he says.
I had a problem with the basis of the application. What
Yeah,
is
fine,
contained
but
in the
at least
heads of
you
arguments.
prepare an application to oppose based on what you think.
That was going to be difficult, my lord,
What would be difficult?
to think what he's going to say in his heads of arguments.
No, he says he wants to recall Mr. Steyn, Colonel Steyn, and Steyn was a witness in this case. He must have said something. So you read the evidence of Mr. Steyn. I've done it, here it is. I've read it, here it is. I've read it, all of it. Right up to Miss Pinky, telling him. And I came with the DOI. I prepared. That's how you do it. But you want overnight now. Overnight. I'm prepared to stand down for an hour, in fairness to everybody, okay? After that we commence.
Thank you.
Initially put as high as that criminal charges will be contemplated. However, later this was then put as follows, that a complaint will be contemplated against the compiler of the affidavit. Now, my lord, we submit that this is a very serious allegation that must be investigated. If there's a suggestion, as counsel put it, that there was impropriety on the part of Lieutenant Colonel Steyn, we submit, my lord, that it is incumbent upon the state to put those allegations to Colonel Steyn, and he be given the opportunity to comment on those allegations. And my lord, this is the reason why this application is being brought, in order for Lieutenant Colonel Steyn to come and clarify the nature of these two calls that accused number 5 is said to have made to Ms. Kelly Kumalo. In other ways, as to whether they were made using data or internet connection, or whether they form part of incoming and outgoing call data, which Ms. Fathillingham referred to as AMA data in paragraph 1.6. My lord, you mentioned that the role of Lieutenant Colonel Steyn as an analyst might have been misconceived. He testified as follows in cross-examination by Advocate Mshololo on the question as to how he established that the various numbers that he mentioned in his affidavit as being associated with accused number 5. And this we see on the record of the 1st of August 2023, page 6, lines 16 to 20. He testified as follows, and we quote his evidence. That is correct, but also I can also mention, after I received the information from Brigadier Gininda, I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downloads. And in a question asked in clarification by the court about his role as an analyst, he then put it clearer as follows, and this appears on record of the 1st of August 2023, page 11, lines 10 to 16. The court asked the question, that was during the cross-examination by Advocate Mshololo. Because, like he says, when I understood him to say that the investigation is ongoing and giving him as an analyst, or given that he's an analyst, some of the downloads, even the section 205, and he uses that information to try and identify the persons who are associated with the numbers which they found from the downloads. The court asked Colonel Steyn, am I correct? And Colonel Steyn answered, that is correct. And my Lord, that is the nub of his duties. He's an analyst. He's giving information emanating from section 205, and Ms. Fathilingam explained the process that they generate the information PDF format, but when it's given to the technical support unit of the police, they're able to convert that to Excel spreadsheet in order to do the analysis. In paragraph 1.8, we therefore, my Lord, respectfully submit that the state ought to be allowed to recall Lieutenant Colonel Steyn to clarify the issue of the two calls, to clarify whether the source of information of the two calls is cell phone downloads or section 205, and also to clarify the information that appear on pages 26 and 27 of his affidavit, and the use of terminology such as MTC and MOC in his affidavit, which, as we have seen, my Lord, the terms are used in the section 205 data. Paragraph 1.9. Now, when the state re-examined Lieutenant Colonel Steyn, also during the proceedings of the 1st of August 2023, at pages 14 to 15, in re-examination, the state posed the following question, and we quote, "You were asked by Advocate Mshololo as to how you established that number which ends with 202 and the complete number is 073-305-9202 made contact with the number belonging to Ms. Kelly Kumalo ending with the number 4358. You testify that you used the information derived from the investigating team as well as your own searches. Can you just clarify the court as to what those searches entailed?" Then Colonel Steyn answered as follows: "I took the SAP, the section 205. I can show that to the court. This is the way we receive it from the service provider. And we throw all this information in a central database. And then on my AMB notebook program, I can go for a search. Then I put it in the number which I received from the investigating team. I can put in any number. Then the program will pick up the number and point it out to me. Just for the purpose of the court, here I highlight that one extraction of my statement. there is a number mentioned. You can actually see just the number before this one. She did not make contact. She did make contact with Senzo. And even if you go a few up, you will see she did speak to Zandile as well. So it is definitely her phone number which she used to contact her friends. And that concludes that portion of his evidence. In paragraph 1.10, we submit, my lord, that it is essential that Lieutenant Colonel Steyn be recalled in order to clarify these aspects so that the truth can be determined, and thereby enabling the court to arrive at a just decision on the case. And we submit, my lord, that there might be fail of justice if such explanation it's not considered. And in paragraph 1.12, my lord, we mentioned that this evidence, it's not about being favorable to the state or the defense, but about the truth being determined in order for the court to arrive at a just decision on the case. The court has been at pains to explain the duties of the state, the duties of a prosecutor, namely to put all relevant evidence before the court that will enable the court to come to a just decision on the matter, and not only incriminating evidence, but all evidence, my lord, that will assist the court in arriving at a just decision. And, my lord, it pains the state if there's a suggestion that we would have put evidence that is improper before the court. And it is for this reason, my lord, that we want to put the matter beyond doubt. If the explanation is in favor of the accused, by all means. But the state, my lord, would like to the correct interpretation of his evidence to be put on record. Paragraph 1.3, we mentioned that the explanation by Lieutenant Colonel Steyn might foreclose the request of accused number 3 or the instruction to his counsel that charges or a complaint be laid against the compiler of the information, and that we submit, my lord, will save the scarce state resources. In paragraph 1.14, we mention, my lord, that the factual metrics of this case will assist in determining the existence of any motive should this become necessary for the commission of the crimes in question. Hence, it's important that the issue of the calls be resolved. Paragraph 1.15, we have tried, my lord, to look at the relevant authorities or the relevant procedures in the Criminal Procedure Act regarding the recalling of a state of a witness. Looking at some other jurisdictions, especially in the UK, it's based on the rule of practice to ensure that justice is done. We mentioned that it is neither the re-examination of a witness as provided for by Section 166 of the Criminal Procedure Act 51 of 1977. It is more based on Section 173 of the Constitution, Act 108 of 1996, which states that the Constitutional Court, the Supreme Court of Appeal, and for our purpose, the High Court, have the inherent power to protect and regulate their own processes and to develop the common law taking into account the interests of justice. So the interest of justice is a prime consideration in deciding whether a witness should be recalled. And this power is already vested in Section 167 of the Criminal Procedure Act, which states that the court may, at any stage of criminal proceedings, examine any person other than the accused, and may recall and re-examine any person already examined at the proceedings, and shall examine or recall and re-examine the person concerned if his evidence appears to be to the court to be essential for the just decision in the case. We have come across a case, my lord. It's not really on point. It's more about the leading of new evidence after the state has closed its case, but we submit that the principles are equally applicable. And this is the case of State versus Felthun. Is F-E-L-T-U, I'm sorry, T-H-U-N, Felthun, and is a decision of the Supreme Court of Appeal. It's recorded in the 1999 Volume 1 SACR at page 481. And this case was concerned with the presentation of new evidence after both the state as well as the defense cases have been closed. And at paragraph 486, I'm sorry, page 486, paragraph B, the SCA remarked as follows: the first question which thus arises for decision in the present case is whether the trial court ruling allowing the reopening of the state case constituted an irregularity. And as I mentioned, my lord, this is in the context of reopening of the state case to present new evidence. But the principle distilled in this matter is equally applicable to an instance where the state seeks to lead evidence to rebut the type of assertion or complaint that was leveled or intended to be leveled against Lieutenant Colonel Steyn. In paragraph C, the court held that a trial court has a general discretion in both civil and criminal cases to allow a party who has closed his case to reopen it and to lead evidence at any time up to judgment is beyond doubt. So the court here, my lord, mentioned that up to the judgment state, a party is allowed to present evidence on the proviso that a proper application is made, as the state is currently doing.
No, yeah, but I hear you.
Yes.
But the SCA also says that the case you're quoting is after argument, is that not so?
Yes, yes.
In other words, the state leads evidence, cross-examination by the defense, close your case, the defense leads evidence, cross-examination, you close, the defense case is closed. Then the parties argue. They argue. All the two parties argue. They say, the SCA says, even after the parties have argued,
Yes.
we can apply for a reopening
Indeed.
of
Yes.
either of the cases
Yes, indeed.
and re-lead evidence, even new evidence.
Yes.
Unlike in this case, for instance,
Yes.
there is no argument which has been proffered by the state after its case was closed, etc.
Yes, indeed. We, in fact, still busy with the state case.
Okay, fine. Now I'm just saying
Yes.
it can even be done so that we are all at idem,
Yes.
even after argument,
Yes.
in exceptional cases. That's what the SCA says.
Yes, indeed, my lord.
Okay, fine.
That is what the SCA held in this matter. And the court then went on to hold that the proper approach is that the court's discretion should be exercised judicially upon a consideration of all the facts of each particular case, having due regard to the considerations mentioned in the cases and applying them as guidelines and not as inflexible rules. The court then referred to the case of Mkonazi versus Van der Merwe and another, 1970, Volume 1, Essay 609. Also the decision of the then appellate division where Holmes J.A., as it then was, held the following at paragraph 616B to D. Says, it is inappropriate for judicial decisions to lay down immutable conditions which have to be satisfied before the relief sought can be granted. Over the years, the courts have indicated certain guiding considerations or factors, but they must not be regarded as inflexible requirements or as being individually decisive. Some are more cogent than others, but they should all be weighed up in the scales, the pros against the cons. Then the majority of the court in that matter held that on the facts of that case, that fresh evidence should have been admitted by the magistrate after both sides had closed their cases, even though there was no satisfactory explanation as to why the evidence had not been led before. So we have earlier on debated the issue of new evidence being admitted after argument has been presented. But here in the Mkonazi case, the court said even after the close of the case for the respective parties, new evidence may be admitted. Then at paragraph I on the same page, the court held, referring to Wigmore on evidence, that nevertheless, situations might easily arise in which an honest purpose may justly be served without an unfair disadvantage, but admitting evidence at this stage, and it is always, or it has always been considered that the trial court's discretion should not be hampered by an inflexible rule. So at the end of the day, my lord, it's the trial court that has got a discretion, and these decisions that I've just referred to have held that this discretion should not be unduly limited.
Yeah, but still, even though we know that the discretion, which also arises from Section 186,
Yes.
must be used judicially and very sparingly, but the defense still have an opportunity to cross-examine Steyn.
Yes.
It's not like the court, if it does, it's not like the court admits the application on behalf of the state that the state should recall Steyn.
Yes.
General principles apply also that even after that, having led Colonel Steyn to explain whatever you want him to explain, the defense has got the right to cross-examine Steyn and put the version of their clients regarding that evidence of clarification.
Yes, indeed, and that speaks to the issue of prejudice, my lord, that there'll be no prejudice since the defense will be allowed to cross-examine Colonel Steyn.
And the defense also has the right to rebut that evidence by also calling a witness who will rebut the very evidence you're saying you want to recall Steyn to come and adduce before this court.
Yes, indeed, my lord.
Okay.
Then paragraph J, this on the same page, the court then held that with regard to the test to be applied to an application to reopen the considerations mentioned by the court include the following. One, the reason why the evidence was not led timelessly, and we will address that shortly. And secondly, the degree of materiality of the evidence. We've already mentioned, my lord, that it is important that this issue be cleared up. It might help to resolve the issue of motive if the issue is satisfactorily explained. But more importantly, it's important to know as to what happened. Were there such calls, or as Steyn testified, or did he perhaps make an error? And it's for him to come and explain that, my lord.
No, but what I'm interested in also, if he allegedly did make an error, was it picked up by the defense, for instance, that your evidence does not make sense or it's incorrect?
Well, looking at the cross-examination, in fact, it just focused mainly on the source of the numbers. You know, it did not really go to the heart of the issue that the court is raising. It was not seriously contested or put in the same vein as it was put to Ms. Faithillingham.
So in other words, if I understand you, are you saying Colonel Steyn was never pertinently told that he has tampered with the evidence, he has created evidence or manufactured evidence and materially changed it to such an extent that it borders on fraud?
Yes.
Was it ever put to Steyn?
No, and that is why, my lord, we're saying that it's important that he should come and answer to the allegations that has been put to Ms. Faithillingham.
So the allegations are put to Ms. Pinky Thallingham, who is not a compiler of that document.
Indeed, my lord. And as we've mentioned, that it's important that the compiler of the information, and that's Lieutenant Colonel Steyn himself, that he should come and respond to those allegations. They cannot be left unchallenged on record and forever remain as a question mark regarding his evidence. He can easily just come and explain those two calls, and whichever way the explanation goes, that will be in the interests of justice, my lord, because that will help the court to then arrive at the truth.
But doesn't this impinge on reputational damage? Because Steyn and
Ms. Faithillingham, yes.
but These are said to be expert witnesses.
Yes.
And if it is put to them that they are contriving evidence, they've tampered with evidence, they've fraudulently planted evidence before this court, don't you think that impinges on reputational?
Yes. Yes, well, indeed, my lord, the police on a daily basis, they analyze information received from network providers,
Yeah.
and it is important that the court should be able to rely on their evidence, and it is therefore important that this issue be explained. And also, as I mentioned, my lord, that the state would also not be party to any evidence that is improper. We would also like to have this issue clarified so that the state can then be convinced that it presented evidence, my lord, that is free from any doubt, any impropriety. And it's important, my lord, that that issue be clarified.
If I recall, Mr. Nisi said the intent preferring a complaint, a charge of fraud, perjury, uttering and blah, blah, blah. You remember that?
Yes.
What was the submission by Mr. Nisi?
Yes, to all involved, not only against the compiler, but apparently against
Even the state.
All the state.
The prosecutors themselves.
Yes. That's how wide-ranging that and breathtaking that allegation is. Then at page 487, the courts then laid out the criteria to be applied. I've already referred to the reason why the evidence was not led timelessly. The degree of materiality of the evidence, that is what we've just debated. The possibility that it may have been shaped to relieve the pinch of the shoe. This is precisely what we've just debated. The possible prejudice to the other side, including such factors as the fact that the witness who could testify in rebuttal may no longer be available. In this instance, we're in the fortunate position that even if Lieutenant Colonel Steyn has retired, he has made himself available. And then the stage which the proceedings have reached and the general need for finality. We are at a point where the state case has not yet been closed, and we submit, my lord, that as we did earlier on, that no prejudice will be suffered, as the defense will have the opportunity to cross-examine the witness and also lead evidence in rebuttal. Then coming back to our heads, on paragraph 2 of page 4, the explanation as to why the evidence was not sufficiently clarified in evidence in chief, in paragraph 2.1. My lord, we mentioned that these are highly technical issues, and Lieutenant Colonel Steyn, that in his evidence, these issues might not have come out as clearly as to what the source of the two calls was, whether they were data or internet calls or normal incoming or outgoing calls or AMA data, as we've mentioned. And with the benefit of Ms. Fathilingham's evidence of how incoming and outgoing calls are captured on the network, the NEMO, we submit that it is essential for Lieutenant Colonel Steyn to put his evidence in its proper perspective. In paragraph 2.2, we mentioned that, and this is the issue that has already come up in the debate, in cross-examination of Lieutenant Colonel Steyn, there was no suggestion that page 23 of his affidavit is false, and we submit that it's only fair that he must get the opportunity to comment. Then, my lord, we deal briefly with the interest of justice. We submit that it is in the interest of justice to allow the state to recall Lieutenant Colonel Steyn to clarify the source of the two calls. We refer to the case of R versus Hepworth, 1928 AD 265 at 277, which has previously been debated before this court, wherein the court held that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. We also refer to the case of State versus Sheikh and others that we have previously referred to, reported. We give the citations there. 2008, Volume 1, SSCR, page 1, decision of the Constitutional Court, given on 2 October 2007, where the court held as follows, and we quote, the applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. Then we lastly refer to the case of multi-choice and others versus the National Prosecuting Authority, and another, and we give the citation there where the Supreme Court of Appeal, per the current JP of this division, then he was attached to the SCA, he had as follows. Our Constitutional Court has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And reference was made to the case of State versus Jukuz and others, wherein the court confirmed that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair trial, fair criminal trial, and what infuses its purpose is for justice to be done and also to be seen to be done. And in S versus Dlamini and others, we give the citation there where the then Constitutional Court, Judge Krichler, described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what would be fair and just to all concerned. It is therefore respectfully submitted that the state be allowed to recall Lieutenant Colonel Steyn We've already mentioned, my lord, that the state will never be party to any evidence that is contaminated, that is improper, and the state will never present such evidence before court. We therefore request, my lord, that this issue be clarified by allowing Lieutenant Colonel Steyn to be recalled. I think that is all.
Okay, Mr. Prosecutor, Mr. Interpreter, can you interpret the gist of the application for the accused?
As the court pleases. Lokho-ke kufakwe isicelo sesifakwa umshushisi. Lesi sicelo lesi sizama ukuthi kuphinde kubuyiswe uLieutenant Colonel Steyn ukuthi azochaza nge-affidavit yakhe. Khona akuyo ka-affidavit nokunye mhlawumbe kwasho kubufakazi obalethwa nge-affidavit kaMiss Mamuva Tillingham. Futhi-ke i-state-ke ushuthi umshushisi ufuna lokhu ukuthi kuphinde kubhekisiswe kubukezwe kahle ukuthi ingabe kukhona yini ukungahambi kahle noma ungafaki kahle kofakazi obuthize obalethwa uColonel Steyn noma uLieutenant Colonel Steyn, ukuthi-ke akwazi ukuthi azoziphendulela achaze kahle ukuthi kuzwakala ukuthi lo bufakazi ayiletha babufakazi obunjani, futhi-ke nokuthi-ke kususwe-ke ukungabaza kokuthi lo bufakazi obalethwa la kokungekho ukukhwabanisa kulo bufakazi obalethwa la, ukusho-ke ukuthi-ke uma elethwa la enkantolo uzofike aziphendulele ngendlela yokuthi-ke angabuza umbuzo aphinde naye aphendule. Is the court please? Yes.
You said you are not opposing. I'm not opposing that. Yes, then Mr. Nis, it's your turn.
As it please the court.
Baloyi.
As it please the court, madam. Firstly, my lord, thank you for the indulgence.
Okay.
Remember, the court initially verified with me, actually wanted to find out from me whether am I opposing the application or not. Then I said no. I need to go first, read what is contained in this application by the state. Then I'll come so that I can formulate. And this is my formulation.
Okay.
I do oppose the application.
Yeah.
Thank you, my lord. Now, before I get to the reason why I am opposing the application, my lord, let me just clear certain issues that the court raised with the state when the state was addressing the court in this application. Now, the court says, what I put to Mrs. Vittelingham seems to be bothering around the question of reputational damage. And the state says yes, actually it does, to such an extent that it involves all the segments that is involving the state, being the investigating team, the prosecution, and everybody else. And according to what the court has in mind, that bothers around reputational damage. But that suggestion, my lord, and I'm saying this with due respect, seems not to take into account or lose sight of the fact that what I put to Mrs. Vittelingham was not something that I thumb-sucked. It was materially based on what the state presented as documents and on the analysis of the documents that were presented by the state. And a person with a background of a criminal justice system with that information would have done a disservice to the criminal justice system as well, not to have hinted that what was reflected in those papers actually does constitute fraud. Fraud being a misrepresentation of facts. After those facts were misrepresented, they were uttered, it means they were presented It does not end up there, my lord.
Yeah, thanks, I'm with you. So, but the fraud then, is it uttered by Steyn or is it by Ms. Wallingham?
We are not yet at that stage, my lord. We are not yet at that stage. It is not for this court to determine who made that uttering.
No, I was in this court. Ms.
Yes.
Wallingham was reading, or he was being cross-examined on the affidavit
Yes.
of Steyn.
Yes.
All I want to know was the alleged fraud directed at Steyn's affidavit or Ms. Wallingham's interpretation being cross-examined on Steyn's affidavit, or is it her own personal view and evidence under oath?
I think I made myself very clear, man.
Okay, fine.
That
Okay.
in an event that there are complaints that are going to be late, and we're still contemplating that,
Yeah, fine.
that those complaints will be made by the compiler of that statement, which would have been Exhibit 01 in the circumstance.
And who's the compiler?
The document speaks for itself, my lord.
Is it
I need
Mr.
not speak
Steyn
on
or
behalf of
Ms.
the
Wallingham?
document. No, I'm saying the document speaks for itself.
Yeah, but I want to know, is it, who compiled the document?
The document, my lord, has been handed in as Exhibit O, as an affidavit.
Of
So
who? Of
at the
who?
inception, at the very first paragraph of that document, it indicates who the compiler of that affidavit is.
Who is that?
The document, as I say,
Now,
my lord,
Mr.
speaks
Mnisi,
for
you're an
itself.
officer of this court. When the court asks you a pertinent question, you've got to
Yes.
respond to it. Who is the compiler? That's all I want to know.
The document, according to this document, and that is not me saying that, according to this document, the affidavit was penned by Mr. Steyn.
Colonel Steyn, fine.
Yes. Letters on their good reputation. But this is not the case in this case. This is what the state produced, and this document has not been produced either by the defense, it comes from the state, my lord. And further on, my lord, I heard the court said that I said the basis of the complaint will be fraud, uttering, defeating the ends of justice, and blah blah blah. I can't recall saying blah 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 blah, my lord. I was very specific. I said fraud, uttering and defeating the ends of justice.
And forgery?
No, forgery, I never
Oh,
mentioned
so they didn't
forgery.
forge the document?
No,
Okay.
I never mentioned forgery.
Okay, fine.
Yes. Now, my lord, let me come to the reason why I say I oppose this application. Now, the court will be well aware that at the very inception of this case, from the date on which a complaint was laid about this case, the state started to do investigation with regard to the complaints that emanate from this case. It went on for some time, up until the date on which the state says, we've now got all the information which will then enable us to start to point certain fingers against certain individuals, which we then suspect to have been involved in this case. And this we are basing on the information that we have gathered up to thus far. So the state says. And indeed, what the state did after they've accumulated that information, they then decided to arraign all these four accused persons, the 5 accused persons that are before court here, on certain charges, and which is the reason why we're here now, here at the High Court. Now, in the process of analyzing the evidence that the state has against those that it intended to indict before this court, the state must have come across this information, and that is not a reputational damage. The state must have had come across this information such that when they then started to present their evidence, it was then incumbent upon the state to bring it to the attention of Mr. Steyn, or even before Mr. Steyn comes and testify here, and or Mrs. Viti Lingam, during their consultation, if ever there was a consultation, and I do not insinuate that there was never a consultation, but a prosecutor, an ardent prosecutor would have picked up this information even before the two witnesses come and testified here and took up these issues with them. And when they came to testify here, Mr. Steyn would then have been referred to this information and said, but Mr. Steyn, look, this is what Mrs. Vittilingam says. I mean, this is what the affidavit of Mrs. Vittilingam contains, and this is what your affidavit contains. What is a probable explanation for this discrepancy? Had the state done that, would not have embarked on this exercise, my lord.
Against the deadline
No,
of
but I'm still
cross-examination.
addressing the court, my lord. Mr. Baloyi had addressed that. He would have an opportunity to respond. He would have an opportunity to respond. I'm not so sure whether I need to proceed or give Mr. Baloyi this rostrum to proceed, my lord, for the whole day, and then we listen to him.
Let's
my lord.
proceed. He will
Excuse me, my
respond if
lord.
he wants to. You can make a note of that, they say.
Excuse me, my lord.
I say you say he will respond if he wants to.
As it please the court, my lord. Thank you, my lord. Now, it is very late for the state to come now and say, no, we want to recall Mr. Steyn to come and address certain issues which came out when Mrs. Vittilingam was cross-examined. Now, basically, all that the state is doing now is to do damage control, which is not a legal requirement for a recalling of a witness, my lord. The state did have an opportunity, on the basis of what I've just submitted, to take this aspect up with Mr. Steyn when he proffered his testimony there. For what the reason why they did not do that, I don't know. Probably the state would come and explain that when he responds. And I can only hope, and sincerely so, my lord, that the state does not come up and say that is yet another reputational damage. My lord, it is a procedure unheard of. It is a procedure which turns our criminal justice system into a hollow of mockery. What the state is doing now is requesting this court to justify or to grant an application in its favor, an application that will turn this procedure, which has been so painstakingly laid in terms of more than 300 sections in terms of the Criminal Procedure Act, where the legislature sat it down and said, this is how we're going to regulate our criminal justice system. Now the state is requesting this court to simply overlook that in the interest of administration of justice. Administration of justice, my lord, does not mean that the standing rules of procedure and protocols and conventions which have been applicable for so many years should simply be overlooked in the name of administration of justice. So that phrase, administration of justice, encompasses or includes in its broader understanding and perspective a respect of the procedure that has been there for a very long time. As I'm saying, my lord, all that the state wants to do here, because of the embarrassment that has been evinced in cross-examination of Mrs. Vittilingam of what the state's case is all about. They're just simply in a process to do damage control. Now, as I'm saying, it is unheard of, my lord, to try and come and do damage control on an aspect of an evidence that came up when a particular witness was being cross-examined. That is best left for argument, because it is this court and this court alone, as a listener to the facts and the metric of the case, that is obligated to make a credibility finding. And more so, my lord, let me just sound a word of warning to the state that the very same process that the state is now embarking upon might come and haunt them very terribly. They are in a grave now, which is 6 feet down. They are busy digging a grave that is going to take them 24 feet down. Because the reason why I'm saying this, my lord, is because ultimately the court will be called upon to make a credibility finding. Mr. Steyn would come and give a version that is different from a version that he gave initially. And I can tell you, my lord, that the state is going to find it very difficult, because we are going to have an opportunity to cross-examine him. The state is going to have a very difficulty in trying to reverse all the little gains that the state has made thus far, my lord. I am saying, my lord, administration of justice does not permit a recalling of a witness to come and correct issues of contradiction that came out when a particular witness was cross-examined.
I thought Mr. Baloyi said to come and clarify. Maybe I'm wrong, but as I'm sitting here listening, I thought the application is about the clarification, not the correction.
That's just
Okay, I'm just saying it. You can argue it further.
That has also never happened, my lord. Whether it's clarification,
okay, fine.
Whether it's clarification, whether it's correction, whether it's
not in our law.
It's an elongation. I've never said it's not in our law, madam.
You say it has never happened.
It has never been heard of.
That's it. It means it has never happened.
For a party to recall a witness who he has an opportunity to lead in evidence in chief,
okay,
who also had an opportunity to re-examine that witness after that witness was cross-examined, to have a third bite on the cherry.
Okay,
it's a very strange process indeed, my lord. Now the state has referred to this court, my lord, to some authority relating to the reopening of a state of a case by any party after the closure of both parties' case. Now the state wants this court to believe that the principle is applicable. No, the principle is not applicable, my lord. The cases that the state referred to this court, in fact, the cases that the state referred to this court to are utterly distinguishable from what is happening in here. Nobody has actually closed their case here. If the state actually wants to recall Mr. Steyn, it can only recall him for purposes of new evidence. And that would basically mean that the state has got to qualify the reason for the recalling of Mr. Steyn for that new evidence in terms of the passage that the state has that the state has actually read to the court. The reason why that new evidence was not read earlier on. But that authority is not applicable for purposes of recalling a witness in order to come and clarify, so to speak, by the state, issues that emanate from cross-examination. That is unheard of, my lord, which is the reason why I am saying the state, because it's rattled in one way or the other, simply embarks on a process to do reputational damage, my lord. Now, and the reason why, my lord, I say the state is embarking on a process to do reputational damage is not far-fetched. I mean, it is not a reputational damage, damage control. I'm sorry, damage control, not reputational damage, but damage control. And the reason why I'm saying that the state is embarking on a process to do damage control, my lord, the state itself accedes to that. Look at paragraph 1.13 of the state's heads of argument. They are basically conceding that this whole exercise is for purposes of damage control. And let me read what the state says in its own heads of argument, that they are conceding that we have been rattled to therefore want to do damage control. And this is what they say. An explanation by Lieutenant Colonel Stein might foreclose. That term foreclose simply means to rule out or prevent the request of accused number 3 that charges be laid against the compiler of the information, saving the scarce state resources. Who said the state has got scarce resources? Who said that? Particularly in the context of a quest where this accused person, upon being convicted, they potentially facing a term of life imprisonment, and we are being told by the state that we need to save the scarce state resources by limiting the rights that is by limiting the right to a fair trial that these accused persons are having. That is very unfair, my lord. This is just a demonstration that this whole exercise is nothing else but an endeavor by the state to do damage control. Now, on paragraph 1.4 of the state's heads of argument, this is what the state says from line number 5. Thereafter, it was put to her, that is now I think Mrs. Vittilingam, that accused number 3 has given instructions for criminal charges or complaint to be laid against the compiler of the affidavit. This is a very serious allegation that must be investigated. The allegation ought to be put to Lieutenant Colonel Stein and be given the opportunity to comment. What procedure really underpins that, Madam? Because this information emanated from cross-examination, and I've already said that this should have been picked up by the state during the preparation of this case, that there is this discrepancy here, so that Mr. Stein, when he came here and testify, he should also allude to this. But nonetheless, my lord, I haven't heard of any suggestion such as this one, that when a person who wants or when a person wants to go and lay charges against a particular person, then they need to go to him first and say, this is what we're going to do. So you therefore need to therefore you ought to have a comment or to answer to this allegation. That's not the duty of the complainant. Once a complainant identifies that a wrong has been done, there is nothing that prevents him to go direct to the law enforcement agencies to go and lay a complaint against the person who or she thinks that is on the wrong side of the law. And it will be for that forum, subsequent to the laying of that complaint, that will have to go and determine all the aspects and the dynamics of that complaint. So the state basically says that we ought, in other words, we must, as a basis of this application, that Steyn must be recalled, that we must come and tell Steyn that Steyn, we, amongst others, we consider, I think you'll be standing there, Steyn, amongst others, we are considering to go and lay charges against you, and the basis of those charges are going to be fraud, uttering and defeating the ends of justice. That's just a hogwash, my lord. Ultimately, my lord, let me say that this exercise that this state wants the court to embark upon is nothing else but to remove this embarrassment that is on their table, which is based on the discrepancies which have been identified when Mrs. Whittingham came and testified here. She was also at pains to say, yeah, no, yeah, I smell a rat, and a very rotten rat, because of, I don't know, because of what reasons. But everybody could see that she was at pains at that meeting that there was indeed a fraud here. I would therefore request, my lord, that there are no legal basis, that this application by the state is baseless. It's flimsy. It has got no legal basis. It will be procedurally incorrect. It will be unlawful. It will be unreasonable. It will be unjustifiable, no matter how much amount of reasoning there might be for it, that this application.
My lord, firstly, I must state that I'll be making my submissions from the bar. I did not get an opportunity to prepare my heads of arguments.
No, fine.
And secondly, my lord, I wish the court to take into account that the state has referred in its heads of arguments to relevant portion of the transcribed records. I did not visit the portions of the transcribed records due to the limited time, as well as to go through the decided cases referred thereto. My lord, this is a state, the state is bringing this application to recon Lieutenant Colonel Steyn. His evidence in chief and cross-examination have already been concluded on the 1st of August 2023. The state, my lord, says that the two reasons that they are intending to recall Lieutenant Colonel Steyn is to clarify the two aspects which appear on pages 23, 26, and 27 of his affidavit, which is Exhibit 01, and paragraph 9 of Ms. Whittingham's affidavit dated the 16th of May 2024, which is Exhibit J1. From the beginning, I think it is important, my lord, to mention that there is no reason for the state to recall Lieutenant Colonel Steyn. The issues that the state wished to clarify, they can be canvassed during the arguments by the state and the defense at the closure of this case, and for the court to rule or adjudicate on such issues. I must further mention, my lord, that there is no provisions in the CPA, that is the Criminal Procedure Act, which sends us this procedure that the state wished to embark on. In his affidavit, Lieutenant Colonel Steyn, his affidavit dated the 9th of April 2020, he states the following, and I quote: "On the 9th of April 2020, at about 10, I received a CD, Section 205 and cell phone downloads from the investigation officer Brigadier Geninda with information about the following targets. And then he went on to mention the targets that he was focusing on. The focus point, my lord, what is relevant for this application according to the state is the transactions of the 2nd of August 2014 at 22 hours 40 minutes 47 seconds, and on the 15th of October 2014 at 1700 hours 33 minutes 57 seconds. At page 23 of Colonel Stein, he says the following. And I quote, the links from Kelly Kumalo 2782704438 from 2773305920 Fisoguhle Ntuli at Nkani 5 in brackets. There's a table there which details the 2 transactions. But what is of importance and of sharp focus in this application is the other party, which is different from the other party that Ms. Vitilingam told this court about. Colonel Stein says the other party's number is the number 27733059202, which the number he attributes to accused number 5, which made a call to the number ending 358, the number which is attributable to Ms. Kelly Kumar. The very same number ending 202 made 2 transactions on 2 different dates, which is the 2nd of August 2014 and the 15th of October 2014. By this, the suggestion that has been made by the state for everyone to see is that accused number 5 and Ms. Kelly Kumalo are the masterminders who were masterminding the commission of this offense. To an extent that accused number 5, Mr. Ntuli, he procured the services of the other accused in the commission of the murder. What then brings this into sharp focus, my lord, is the affidavit of Ms. Pinky Vitilingam, which came up with a totally different picture about the other party that I've referred to earlier, the other party which is contained in the affidavit of Lieutenant Colonel Stein. Maybe to stretch this again, my lord, I wish to refer the court to page 34 of the affidavit of Lieutenant Colonel Stein. Lieutenant Colonel Stein, my lord, attributes in the layman's term the number 278345713330. That is the number which made a call to Ms. Kelly Kumalo on the 2nd of August 2014 as at 2200 hours 40 minutes 47 seconds as the number belonging to or attributable to Mr. Arthur Mofokate. So in layman's term or in simple terms, it means that on the 2nd of August 2014 at 2200 hours 40 minutes 47 seconds, Mr. Mofokate made a call to Ms. Kelly Kumalo and not accused number 5 as it was detailed in the affidavit of Lieutenant Colonel Stein. On the 15th of October 2014, at 1700 hours, 33 minutes, 57 seconds, Ms. Pink E. Battlingham considered that the number 27714379551, that was the number which belonged to the deceased, which made a call to Ms. Kelly Khumalo on the 15th of October 2014. As I've indicated, my lord, that the two transactions are what brings this application into sharp focus. And it raises an attempt by the state to bring the administration of justice into disrepute, in the sense that the evidence is on record. There is no need for the state to recall Colonel Steyn. The state and the defense can argue on these issues and for the court to adjudicate on in its own judgment at the end or at the closure of the case for the state and the defense. I also wish to re-emphasize the submission which had been made by my colleague, Advocate Mnisi, that from the beginning, when the indictment was drafted, the state was supposed to be in possession of all the documents, that is the Section 205 records, in order for the state to make an informed decision. Other than when we are faced with this situation, a witness has to be recalled in order to testify. That is the danger, my lord, of the piecemeal approach in the presentation of the state case and in the manner in which the state has provided the further particulars, day in, day out, further particulars being provided to the defense. The provisions of Section 35, subsection 3 of the Constitution, one is attempted to mention the provisions of Section 35(3), subsection small letter b in bracket and I in bracket of the Constitution, which provides the following, and I quote: "Every accused person has a right to a fair trial, which includes the right, small letter b in bracket, to have adequate time and facilities to prepare for a defense, small letter I in bracket, to adduce and challenge evidence." Sorry, my lord, may I just go through the provisions of the Constitution verbatim. Small letter I in brackets, that is Section 35, subsection 3, small letter I in bracket. Every accused person has a right to a fair trial, which includes the right to adduce and challenge evidence. The court is well aware, my lord, that we have gone past the stage. The accused have, through their defense counsel, obviously cross-examined the witness, Colonel Steyn, and prefer the defense. I submit, my lord, that when one has to go through the very same exercise of cross-examining the witness, in the instance where the witness had initially been cross-examined by the defense, that will bring the whole exercise into disrepute. It is my submission further, my lord, that the recalling of Colonel Steyn will render the whole trial unfair and detrimental to the accused person. The application by the defense, by the state, I submit, it is a devoid application which has no merit. I will then, my lord, go through the paragraphs of the state's heads of argument with an attempt to reply thereon. In paragraph 1.4 of the state's heads of arguments, towards the last end, it says the following, and I quote, "This is a serious allegation that must be investigated. The allegation ought to be put to Lieutenant Colonel Steyn, and he be given an opportunity to comment," close quotation. In this regard, as I've indicated, my lord, that there is no need for Lieutenant Colonel Steyn to be recalled in this regard, as such issues can be ventilated during the arguments by the state and the defense, and for the court later to adjudicate on. It's page 3 of the state's heads of arguments. I'll quote from the paragraph which reads as follows, and I quote, "You testified that you used the information derived from the investigating team as well as your own searches. Can you just clarify the court as to what those searches entailed?" Mr. Steyn, "I took the SAP, I mean section 205. I can show that to the court. This is the way we receive it from the service provider," close quotation. In this regard, my lord, I must mention that whenever Colonel Steyn was asked about the section 205 records, he will tell or respond in a manner that suggests that he received the section 205 records from the investigation team, and he will not proffer any explanation about how such section 205 records was procured. I must mention in this regard, my lord, that Brigadier Kininda has still to be called to testify in this regard. And he is a person to clarify this. That is the record that Lieutenant Colonel Steyn worked on the 9th of April 2020. As he says, he received the section 205 records from the investigation officer, Brigadier Kininda. It is my submission, my lord, that the application by the state is devoid of any substance, and it tends to be dismissed. That is all, my lord. Thank you.
Okay. What's your time there, Mr.
13:05, my lord.
13:05?
Yes.
Okay, yes, Mr. Mshola.
Which is
My lord.
what we need to...
Yeah, we'll wait half past. Yeah, his lunch not 2 hours, sir.
I'm sorry,
1 hour.
yeah, 1 hour.
Yeah, you can continue.
My lord, I need a break to print out the case law that I want to refer this court to.
To print it out.
Yes.
Okay. You come back at 1:45. 2.
Sorry, section 167.
So wait.
Of the-
Who's invoking these provisions?
The state, my lord.
The state.
Yes.
Oh, they're invoking section 186.
Section 167.
Oh, 167.
Yes. If I read the nature of the application, my lord, to say the court may at any stage of criminal proceedings examine the person, other person than the accused, who has been subpoenaed to attend such proceedings, who is in attendance at such proceedings, and may recall and re-examine any person, including an accused already examined at the proceeding, and the court shall examine or recall and re-examine the person concerned if his evidence, my lord, appears to the court essential to the just decision of the case. My lord, in this case, it is not the court that is inviting the recalling of this witness. And it has not appeared to the court that in his evidence, Colonel Steyn, there is essential to the just decision of the case. In other words, my lord, what I'm trying to say is that it is not at the instance of this court that the recalling of Colonel Steyn is being applied. It is the state. Therefore, this section, the application of this section is misplaced, my lord. It will only be applicable if it is at the instance of the court to recall a witness in order to re-examine or for whatever reason the court may decide. After the state has decided or after the state has observed that there are discrepancies in the state case, the state now wants to recall the evidence. So the state now wants to recall the witness who has already testified. My lord, I want to remind this court that the same state has submitted before this court that the Colonel Steyn is no longer available. He went on retirement. And Lieutenant Colonel Hose was called to come and testify or lead evidence, take over the work which had been done by Colonel Steyn because of his unavailability.
Did the state ever say that Colonel Steyn is no longer available?
My lord, that was the reasons that were advanced when Lieutenant Colonel Hose was called.
But now the state is saying Colonel Steyn
is now available.
And they've spoken to Steyn according to them, but last week they say he was sick. I don't know if it's the position.
Yes, whatever, my lord. But the gist of my submission, my lord, is that the state now is saying Colonel Steyn is now available.
I'll see.
Yes, my lord. Surprisingly. My lord? I have heard the submissions made by the state and the engagements and sentiments raised by His Lordship in this case. However, I want to bring it to the attention of the court that as much as the court may be inclined in granting the state's application.
How do you know that?
My lord, I'm just making...
Yeah, but how do you know that? Otherwise, why should I listen to argument if I'm inclined to grant the application?
My lord, that's what I'm saying in the event.
No.
In the event...
Are you saying I've prejudged this? Please, let's not make such allegations.
My lord, I'm not saying the court has already granted. I'm saying in the event that the court is inclined to grant the application by the state. Yes. My submission is that the constitutional rights of the accused will be violated. Constitutional right of the accused to a fair trial will be violated by the granting of that application for the recalling of the witness, Colonel Steyn, on the following reasons, my lord, why it will be unfair. I will go step by step, my lord, from the heads of the argument submitted by the state so that I unpack clearly each and every point of the unfairness and the extent of prejudice that is going to be caused. Paragraph 1.2, my lord, of the introduction in the state submissions reads as follows. The reason for the application to recall Lieutenant Colonel Steyn is to clarify only two aspects that appear on page 23, 26, and 27 of his affidavit. My lord, the witness is recalled not to come and lead new evidence, but is recalled to come and rectify his own affidavit, to come and rectify his own evidence, my lord, because Colonel Steyn has already testified. The question is, my lord, why, if this clarity the state that wants to sort now, why this clarity was not sought at that stage when Colonel Steyn testified? Because the discrepancies that Colonel Steyn is now called to come and clarify is the discrepancies on the state case between the evidence of Colonel Steyn and evidence of Ms. Pinky Vitilingan from Vodacom. If I read correctly, this paragraph, my lord, paragraph 1.2, because it's referring to exhibit 0.1, which is the evidence of Colonel Steyn, and I have raised and taken the evidence on the and I've taken the witness on the discrepancies between these two exhibits. The state further, my lord, on the same paragraph.
Sorry, just before you go there.
Oh, sorry.
What is an AMA? AMA.
Sorry, my lord, where is that?
Yeah, that's the one. AMB notebook, case data. AMB notebook, case data. Have you ever heard of that? Hello?
No, my lord, where?
You've never heard of that?
No.
Now, let me show you what this guy says. Steyn.
Where's
If you
the
go, yes, let's go to point 1.5. Sorry, 1.6.
Yes.
On page 2. This is what the state says. The role of Lieutenant Colonel Steyn as an analyst might have been misconceived. He testifies as follows in cross-examination by Advocate Mshololo on the question as to how he established that the various members that he mentions in the affidavit as being associated with accused number 5. He says, that is correct, but also I can also mention after I received the information from Brigadier Pinanda, I threw it into the AMB notebook data case. Yes. And then the linkages come with the section 205s and the cell phone downwards. That's what Steyn says. And we don't understand what is AMB. That's what he says, this guy. He says he juggles a system, throws whatever information he wants, and that information throws out some of these numbers. It's not me saying that. Did you read this?
Yes, my lord.
That's it. That's what he says. He says, I can also mention that I received the information from Ginanda. I throw it into the AMB notebook database, and then the linkages come with the section 205s and the cell phone downwards.
Yes.
That's what he says.
My lord, if Colonel Steyn has testified and responded, like the court has just referred me in paragraph 1.6,
Okay.
why is it necessary to recall Steyn?
Hello?
Why is it necessary to recall Steyn?
No,
Because
this
he has
is what
already,
Steyn says.
because he has already mentioned the process that he engaged. already mentioned-
Apparently the state doesn't understand that process.
If the state does not understand that process,
Do you understand that process?
yes, I do.
Okay, fine, no problem.
I do.
Let's
I do.
continue, no problem.
Thank you, my lord. Can I proceed
Yes,
with my line
yes,
of?
yes.
Thank you, my lord. I was still on paragraph 1.2, my lord. And the state says on the second page, my lord, wherein she sets out the transactions for 2nd of August 2014 at 2240 minutes 40 seconds, and on 15 October, those are the two transactions that are in issue, my lord, and calls received from other parties. Colonel Steyn locates, my lord, the two calls by accused number 5 to Ms. Kelly Khumalo at the same time as those reflected in section 205 as testified by Ms. Vitilingam. I'm reading the heads of the state as they are, my lord. Then my response to this, my lord, is that Ms. Vitilingam, in his affidavit, raised a contradiction to the evidence of Colonel Steyn in respect of these two transactions, my lord. And the explanations have been given by both witnesses respectively, my lord, without repeating their evidence, Colonel Steyn and Ms. Vitilingam from Vodacom shop, regarding the two transactions, my lord, which are in dispute or are in issue at this point. In other words, a clear contradiction between the state case has been identified and displayed during the cross-examination. During re-examination, this issue was not raised, and now the state wants to recall the witness to come and clarify a material contradiction which has been displayed before this trial. My lord, it has been conceived, or it has been perceived, that accused number 5 had called the number belonging to Ms. Kelly Khumalo, according to Colonel Steyn's evidence. And according to Ms. Vitilingam from Vodacom, she said she cannot confirm that they do not have such records in Vodacom, and further revealed, my lord, a PDF format of section 205, wherein she said she can only comment on that PDF document of section 205 rather than that of an Excel which was revealed by the state, furnished by the state to the defense.
Was it not utilized by Colonel Steyn, this Excel program?
My lord, we think it was used by Colonel Steyn, the Excel one, but we heard for the first time from Ms. Vitilingam, yes, that's not the document they have furnished to Colonel or to the police. Again, let me say to the state, my lord.
Yes, fine. She says she never finished it. She finished the PDF.
Yes, the PDF. So we
And
don't.
her evidence also was that she doesn't know how Steyn juggles up this Excel program
Yes.
and then conjures up the numbers which are alleged to be fraudulent. She doesn't know. She can't explain it because she didn't use that system.
Yes. So it means Colonel Steyn produced a fraudulent document before this court.
No. How can you say that?
Of which you don't know how was it.
We don't know how Steyn produced it. Nobody knows. It's even new. You don't know.
Yes, my lord.
Nobody knows how an Excel system. I don't know how an Excel system works. After it extracts information from a PDF. I don't know.
Yes, my lord. Whether we cannot be able to to make submission that it was a fraudulent Section 205 record, but it had been changed. It is not original as it was sent by Ms. Vitilingam to the state.
We don't know.
As the court pleases.
No, it's not me saying that. House, for instance, remember House came to this court and gave evidence and told us that when he uses a certain system, the numbers don't get filtrated into the next page. You remember him saying that?
Yes, my lord.
That's it. He explained. Because I think it's Mr. Nisi.
That's unlawful what he did. He was not supposed to change those numbers.
But you're not listening to what I'm saying. Mr. Nisi apparently, I think, asked him a question. Why there appears to be a gap between these numbers on page 7, for instance?
Yes.
Halfway, the information which is contained is not similar to the one which is contained on the other page. And he says when he was working with these figures, some of them get printed out, some of them don't get filtrated into the next page. That's how he said.
Then, my lord,
and that for me and you was an explanation which we did not know.
Then if that explanation, my lord, has been accepted by this court.
No, I've never accepted any explanation. I have not yet even started going over the evidence.
Yes, my lord.
I've never.
My lord, maybe if I can just rephrase to say, if Colonel House has given that explanation before this court, my lord, then what is the need then again on top of that explanation to recall Colonel Steyn?
No, these are two different concepts.
As the court pleases, my lord.
Two different concepts. Steyn's evidence pertains to two numbers, one in October, one in August. Communication allegedly between accused number 5 and Kelly.
But the gist of the matter, my lord, is the contradiction.
Well, people don't want to listen. You're talking about two different concepts.
As the court pleases, my lord.
House never came with an evidence that he personally checked the communication between accused number 5 and Kelly. House says he got that information from the document which was prepared by Steyn. And he took it as it was.
Can I just proceed with the line of my submission so that I don't get distracted on the way?
This court doesn't want to get distracted. I want to follow every argument. I'm not the type of judge who sits and when I don't follow, I say,
The problem is when I'm jumping all over my submissions, my lord, I get distracted.
I see. Okay.
Thank you. The next point, my lord, on paragraph 1.5 of the state hates, it says, this is the reason why this application is being brought in order for Colonel Steyn to come and clarify the nature of these two calls that accused 5 is said to have made to Ms. Kelly Khumalo as to whether they were made using data internet, whether they form part of incoming and outgoing call data, in brackets, AMA, in capital letters, my lord, data. My lord, when Colonel Steyn was testifying, he made it clear without any hesitation that the nature of the transaction that was made between the call, between these two, on these two calls, it was a call, not whether it was a data or internet or whether any form part of incoming and outgoing call data. It was made clear that accused number 5 called the number used by Kelly Khumalo. That's the evidence that I can show before this court under the evidence of Colonel Steyn, my lord. And the explanation or clarity on these transactions, on these two transactions, my lord, was given by Ms. Vitilingam, who confirmed the nature of the transactions that were made from the cell phone of Ms. to the cell phone of Ms. Kelly Khumalo, that there were incoming calls to the cell phone of Miss Kelly Khumalo. That evidence was tendered and is clear before this court, my lord. So there is no need of recalling Colonel Steyn to come and repeat what has already been placed by Miss Vitilingan from Vodacom shop. That's my submission, my lord.
But Ms. Vitilingan did not prepare the Excel notebook.
Yes, my lord.
Her evidence is very clear. The PDF information which comes from the internet onto our server,
Yes.
it's immutable. It cannot be changed. That's her evidence.
Yes, ma'am.
And now I am surprised that there is an allegation that this information which emanates from the PDF finds its way into the Excel program. But when you investigate the Excel program, you find that these two numbers are different, or this information, as Mr. Nisi put it, they materially differ from the PDF numbers. That's the evidence I'm listening to.
Yes.
And Ms. Pinky Whittingham says she cannot explain that because she never worked
Yes.
with the PDF.
Yes.
I mean with the Excel.
Yes, ma'am. But the point
Okay, fine, you've heard me, you can go ahead.
the point I'm bringing to the attention of the court, my lord, is that this witness is being called to come and clarify the nature of these two calls that accused number 5 is said to have made to Miss Kelly. My lord, my submission is that Ms. Vitilingan has clarified from the PDF section 205 record the nature of these two calls.
They are not similar. Mr. Nisi, you can ask him. He calls them materially different. They are not similar.
But my lord, Ms. Vitilingan has explained on the nature of these calls.
Yeah, okay, you can go ahead.
Yes, he has explained on the nature of these calls, my lord. It's not that
Of different numbers, ne?
of different numbers.
That's
yes,
it. Which are
yes.
different from the PDF.
Yes.
Okay, fine.
Yes, my lord. And then point number 4, the role of Lieutenant Colonel Steyn as an analyst may have been misconceived. He testifies as follows in cross-examination, but I'm interested in the answer, my lord, which says, that is correct, but also I can also mention that I have received information from Brigadier Kininda. I throw it into the AMP notebook database, and then the linkages come with the section 205s. Then the problem, my lord, we are sitting in this trial, it's that we have 2 different section 205 records. The one from the service provider and the one from the police, respectively, my lord.
No, police don't have 205. The police rejig the 205 matter into a system called Excel. The
Yes.
police don't control any telephone calls. They are not privy or subject to the internet.
Yes, my lord.
It's only Vodacom which does that in terms of Section 15 of the Monitoring Communications Act. The police get everything from Vodacom, like Ms. Pinky was testifying to. And that the access mechanism is to get certain police who are senior and give them clearance certificates for them to access that information.
Exactly, my lord. My submission is, Steyn had already given that explanation. What more is needed now?
Which explanation is that?
The one that is referred in this paragraph, my lord.
Yeah,
I've
what
just
is-
read it
Yeah,
into
fine.
the record.
Yeah, read it.
Should I read it
Yeah,
again?
yes.
The role of Lieutenant Colonel Steyn as an analyst may have been misconceived. He testified as follows in cross-examination by Advocate Mshololo on the question as to how he established that the various numbers that he mentions in his affidavit as being associated with accused number 5. That is correct, but that is the answer, my lord, from Colonel Steyn. That is correct, but also I can also mention that I received the information from Brigadier Kininda. I throw it into the AMB notebook database, and then the linkages come with the section 205 and the cell phone downloads. Then my submission, my lord, is that Kenneth Stein has already explained, and the state has made a reference to the pages on the transcript record, my lord, of 1 August 2023, page 6, line 16 to 20. Unfortunately, I have not prepared this transcript. I was going to also read it for the court from the record. So in other words, the submission that I'm making, my lord, is that Kenneth Stein has already responded. He has already clarified.
And he never showed this court the AMB notebook.
He had it at that time, the AM book.
Is that so?
Yes, he had it at that time, the AM book. If the AM book was in his position at that particular time, and then now he is being recalled to reveal the content of the AMA book, then that's prejudicial to my client.
Okay.
Yeah, and it's unprocedural and irregular. If he is being called to come and say that, my lord. However, I have not heard the state raising that submission. My lord, can I move further? Thank you, my lord. Paragraph 1.7. Also, it says, in question, as in clarification by courts, his role as an analyst became clearer when it remarked that because, like he says, when I understood him to say that the investigation is ongoing and giving him an analyst some of the downloads, even section 205, and he used that information to try and identify the person who associated with the numbers which they found from the downloads. Who associated with numbers which they found from the downloads. Am I correct? Mr. Stein responds, that is correct. And we are also referred to transcript record of the 1st of August 2023, page 11, lines 10 to line number 16. My lord, I wanted to expand on this. I wanted to reflect and to refer and double check the transcript record regarding what the state has referred to in this paragraph of the heads of argument. However, I have not been given an opportunity, my lord, because we received the heads of the arguments this morning. If I will be given the opportunity in future, I will be able to
Which future are you talking
argue
about?
on this, my
Which
lord.
future are you talking about now?
My lord, after I've finished my submissions,
No, if you want to go and refer, tell me that. I'll adjourn.
as the court
No person must say here he has not been given a full opportunity of laying out his or her client's case.
My
I
lord,
don't stop people from
my lord,
educating me, for instance.
My lord, I will appreciate if I can be given
Yes,
that
I could
opportunity.
give it to you. Well, how long do you want?
But can I proceed so long, my
No,
lord?
no. You want to proceed or you want to check that first?
To check that record, my lord, I don't know what is the time now.
Mr. Mlisi, what's the time?
It's 28 minutes to 3 o'clock, my lord. Actually, it's now 27 minutes to 3 o'clock.
27 and a half.
No, my lord.
Did you catch the joke?
My lord?
Did you catch the joke? Okay.
Yes, I did.
Okay, fine.
I think it's with how much the state.
You watched the 100 meters yesterday.
Yes, I did.
What did you think?
I think that was robbery.
Okay, let's adjourn until tomorrow so that you check the records. I don't want anybody to say he was never given an opportunity to check the record.
Thank you, my lord.
Consequently, his argument became tangential and it was not sequential.
Thank you, my lord. The indulgence.
Sequential. Is that okay, Mr.?
That's in order, my
Because I
lord.
don't know how many... I've got the record here. Yes, Mr. Muhammad. There it is. Let me see it. Rose, give Mr. Muhammad. So that he doesn't say, the judge in Amangalin. I've got the evidence of house and I've got the evidence of stain there. Give it to them. That's why I'm surprised. People come and argue about the evidence which relates to house and stain, and then, yeah, show it to Mr. Muhammad. And they don't come with the record.
My lord, the problem, I did not...
No, fine. I just want to show Mr. Ngumalo.
I did not know the application. Maybe Ngumalo knew what the state was going to bring today.
Yes, the evidence of holes and stone.
Maybe they've discussed.
Do you see that, Mr. Ngumalo?
Yes, I've got the record, I've seen the record.
Yes, thank you. Okay. Yeah, okay, let's come back tomorrow morning, 10 o'clock.
Thank you, my lord.
Hey, come with my records. It's all vanished just now.